Hello, this is Judge Aaron Gothier, the 53rd Circuit Court of Sheboygan and Presque Counties, here with another installment of our Ask the Judge videos. As you've watched our criminal docket, you may have seen several times when we end the live stream and close the courtroom for a youthful offender, or we refer to a plea agreement for HYTA and wonder what in the world are these things and how is this treated this way in an adult felony court. This is not the probate court dealing with true juveniles. Everybody here is 18 or up with rare exception. Well, in Michigan, there's something called the Holmes Youthful Trainee Act, and so abbreviated as HYTA. And lawyers over the years have just used the shorthand HYTA, HYTA. Now, this is a law in Michigan. If you're really interested in the details, you can go to the legislature's website and look at Michigan compiled laws 762.11 to 762.16. This was 1966 legislation. It took effect January 1st of 1967. The Holmes, I had to look this up. I'd been a lawyer for 20 some years and always talked about the Holmes Youthful Trainee Act and didn't know who Holmes was. I had hoped that he was some young wayward person who turned his life around or something, but no, it's one of the co-sponsors of the bill, Representative David Holmes. So his name is memorialized in the Holmes Youthful Trainee Act. This is a law giving special treatment to certain youthful but adult offenders. The Court of Appeals has described its purpose as so as not to stigmatize those youthful defendants with criminal records for what they called unreflective and immature acts. Originally, it applied only to offenders from age 17 to 20. In 2015, it was expanded to include 21 to 23-year-olds. And effective October 1st of 2021, it was expanded again to include 24 and 25-year-olds. And then also in the last couple of years, Michigan has raised the age for adult offenders from 17 to 18. So now HYTA includes from 18 to 25. It also sometimes includes juveniles, 14 and older, if under certain circumstances they are waived into the adult court by the probate court, as happens in rare circumstances. Those people would also be eligible for treatment under the Holmes Youthful Trainee Act. So that's sort of the history. The general eligibility requirements to be in the program now are these. You have to be between 18 years old and 25 years old at the time the crime was committed. If the person was 21 or older at the time of the crime, then the prosecutor must also consent to the HYTA status. If it was 18, 19, or 20, the court can put somebody in the HYTA program even over the prosecutor's objection. Most of the time, there's a plea agreement with that as a recommendation, but it doesn't always have to be that way. The defendant must plead guilty to take advantage of the HYTA program. The statute does not allow HYTA if they are found guilty after a trial, either to the judge or a jury. It also does not allow HYTA if somebody pleads no contest. The statute requires that they plead guilty, perhaps on the theory that to benefit from the program, the person has to voice what they did and accept responsibility for it. There are some exceptions. Certain crimes are not eligible for this special treatment. Any crime punishable by up to life in prison, including, for example, murder, assault with intent to commit murder, or armed robbery, these crimes are not eligible for HYTA status. Certain major drug crimes are not eligible for HYTA status. Most sexual offenses are not eligible, and traffic offenses are not eligible. So drunk driving is not eligible for HYTA. There are other considerations that any judge thinks about in whether to grant HYTA to a younger defendant. It's discretionary with the court. Nobody is entitled to receive it. Even if it's part of a plea agreement, you've heard me say on the criminal docket many times, the court doesn't have to follow those agreements. The court should consider the seriousness of the offense and the total circumstances, not only of the case, but of that younger defendant. Again, the prosecutor has to consent if the person was 21 years of age or older at the time of the crime. There's no limit to how many crimes or counts in a case can be put under the HYTA program. There's no limit to how many cases. There's not even a limit to somebody receiving a HYTA multiple times over a period of time. There's no limit on it except the discretion of the court. If that were happening over and over, I think it'd be rare to find a judge that would give somebody that again. Also, a treatment under the HYTA statute is not considered a departure from the sentencing guidelines. So even if the sentencing guidelines called for prison and the court wants to, instead of sending the person to prison, put them in the HYTA program, they can do that without it being a departure from the guidelines. So what is this program? What are the benefits to the defendant? Well, if somebody's sentenced under the Holmes Youthful Trainee Act, the court assigns them the status of youthful trainee without entering a judgment of conviction. That's the main benefit to the defendant. There's no judgment of conviction. And any proceedings after HYTA has been granted are non-public. That's why we clear the courtroom. That's why we don't put it on the live stream. And if the defendant successfully completes the program, then the court discharges them and dismisses the case. So it's not a judgment of conviction. It's non-public after they're granted HYTA. And if they succeed, then it's just dismissed. So it's not a conviction. So it helps them avoid a criminal record, especially in a circuit court, a felony record. What happens to the defendant when they're in the HYTA program? Well, there are many different things a court can do. One option is there is a HYTA prison option. For certain serious situations, a court could sentence somebody to prison for 2 years, up to 2 years, plus after they're released, another year of probation if the judge wants. That's option one, HYTA prison, up to 2 years prison plus a year probation. Option two is HYTA jail. You can give somebody up to a year in the county jail, followed by an additional year of probation if the judge wants. That's option two, year in jail plus year probation. Or option three is probation up to 3 years. With the exception, if it's a misdemeanor, it's probation only up to 2 years. So I'm primarily talking about the circuit court and felony crimes, but HYTA is available for misdemeanors as well. Obviously not prison, but for HYTA misdemeanors, it's generally 2 years probation. For HYTA felonies, again, 2 years prison plus a year probation, a year in the jail plus a year probation, or up to 3 years probation with no jail or prison at all. The probation requirements should include requirements for education and for employment, along with the typical probation, community service, substance abuse treatment or counseling, anger management counseling, other types of things, trying to address what problems or needs are going on in the offender's life that we can try to connect them with services to address, to try to change the circumstances that led to the behavior. And if the HYTA offender is in for a crime committed after their 21st birthday, the probation can include, if appropriate, a global GPS tethering system. What if somebody misbehaves during HYTA? That happens. We treat it like a probation hearing, and it's discretionary for whether the court wants to revoke that HYTA status. So I can revoke somebody's HYTA status, but continue them on regular probation. Now it's just a conviction enters, and it's a public case, and they'll have a conviction at the end. I can revoke the HYTA and revoke probation and then sentence them to jail, straight jail or straight prison. It depends upon the nature of the violation and the seriousness of what's going on in that person's life. The law does require judges to revoke HYTA status under certain circumstances. So it's a mandatory revocation if the youthful trainee commits a new life offense or a major controlled substance offense or sex crime, or also certain firearms crimes or assaultive crimes are a mandatory revocation. So that in a nutshell is when you hear us talk about HYTA, it's for 18 to 25 years old. Again, prosecutor has to consent if it's 21 or up. It's discretionary with the court. It avoids a judgment of conviction, puts them on a non-public probation, and dismisses the case if they succeed. I can give them 2 years prison before the probation or a year in jail. If I do, the probation can only be an additional year. If you don't give them jail, it can be a 3 years probation. And then you can violate them just like normal probation. If they successfully complete it, then they're discharged and the case is dismissed. So hopefully that gives you a little bit more detail and context when you hear us in court talk about the youthful cases or the youthful offenders or HYTA, and tell you why we closed live stream and even closed the courtroom for those types of cases. And again, if you have any questions about this or anything else with our justice system, either locally or a Michigan question or just a general question, please put it in the comments. And please subscribe and enable notifications so that you know when we're in court and you can watch what we're doing. Let us know if you have any questions, again, in any of the comments to these videos. We'll try to do a video addressing those. And thanks for watching, and I'll see you in court.